Matters pertaining to the principal seat, supply list for delivery of judgment, item 5.
In view of the above discussion, the impugned judgment and sentence is modified by altering the conviction from 1 under section 6 of the POCSO Act to 1 under section 18 of the POCSO Act, and the sentence of 10 years RI is reduced to a sentence of 5 years RI with a fine of rupees 10,000. Appeal stands partly allowed as above.
Deeply allowed.
Principal seat, daily list for motion, item 1.
Earlier rejected by your Lordship on 24/9/25.
This is for motion.
Yes, for motion. Earlier rejection order is at page 36.
Are the council aware? How many days now?
Till today 136 days.
Charge sheeted.
Yes, no, regarding search sheet, I have no instruction.
Must be, otherwise how would he stay that long? 100
36 days. NDPS Act, commercial quantity. (27)A.
I think none of the councils are available.
Regarding other cases, my lord, councils were present.
Call up the next item from the principal seat. We'll take this up a little bit later.
Item 2.
Smith, this is your lord. My lord, second application.
After some time.
My lord, second application, lordship. Lordship may kindly see the rejection order at page 18. Page 18,
The
lordship.
volume is too low, I can't hear.
This is also my earlier rejection order is at page 21, my lord. 21 minutes.
How many days in custody?
My lord, 65 days as on today, lordship. And the similar petition was filed by another two accused persons, second application. They were enlarged on bail in the motion stage itself on 1st of this month, lordship. My lord, 65 days, I am praying for enlarging them on bail, lordship.
Present petitioners, my lord, rejection order is at page 18, my lord.
Page?
18.
Page 18 is the rejection order. Lordship, page 21 is another rejection order of another two accused person. And those two accused persons filed subsequent bail application and your lordship was pleased to enlarge on bail. That order is at page 24. On the motion stage itself, they were enlarged on bail, lordship. Page 24 is that order, lordship.
Items
And
have been recovered, it seems.
Yes, recovered, lordship. That is also observed as page 26 of your lordship's order. Items recovered. Page 26, para 5, lordship may kindly visit. 65 days in custody, lordship. And the items were recovered from those two persons, lordship.
Regarding, my lord, other two accused persons, they are the, my lord, purchaser of the stolen articles, and he is the person who is involved in committing the theft, my lord. And section
In the present case, the present petitioners, they were the actual
yes.
thieves.
But
Thieves.
Yes.
Yes.
lordship, considering the length of detention, lordship, 65 days, lordship. I am paying for on length of detention, lordship. Any condition, lordship, they will face trial now, lordship. They will cooperate also with the investigation. Lordship may kindly consider length
Right,
of
we have
detention.
released they are guilty in equal measure. Since we have released the others, I think considering the length of detention, we can let them go now. Yes,
Yes, my lord, otherwise section 331(4) is there, my lord, and the present petitioner is the main person who is involved in committing the theft, my lord. And regarding other accused persons, they are the purchaser of stolen articles, and those, my lord, are, my lord, value of more than 5 lakhs, and those, yes, those articles were already recovered. On that ground, my lord, those two other persons were earlier granted by your lordship. Regarding length of detention, I will leave it to your lordship, my lord. Otherwise, my lord, considering the, my lord, materials against the accused persons,
yes.
your lordship also fix a short date, my lord, that is
Length of
for
detention will-
updated CD.
Others are already enlarged on bail on 1st of this month, Lordship, 11 days back, Lordship.
But what will the updated CD show? All things are anyway clear.
Yes, yes.
Their role is very much clear. We are only on the length of detention now.
Yes, my lord.
All right, hard. Say page 25 order, okay? 11225 order, para 1, 2, 3. Names will be changed. 4, in para 4 you write 65 days instead of 54. Para 5, on the other hand, learned additional PP submits that as reflected in the earlier bail rejection orders, the present petitioners are the main perpetrators of the offense of theft of the stolen articles. Para, then next para 6, okay? Here also instead of 54, write 65. Para 7, same, okay, same conditions. Eight, 9. Yes, we have allowed it.
Deeply obliged, Lordship.
Item 3,
May it please your Lordship. Lordship, this is second bail petition earlier rejected by my lord. Page 22 is the earlier order, madam. By where accused number 1 was granted bail. Now the other accused, madam. Page 22. So this is my prayer, my lord, update case diary is called for.
All right. Heard Mr. Suresh, learned counsel for the petitioner, and Mr. Bothago, learned additional PP. Call for the updated CD, list the matter again on
On
5th,
7th of January. Then
7th of?
January, 7th of January, 7/1/26, my lord.
All right.
My lord. It may be, my lord, 8-1, my lord.
8-1.
8-1.
All right, 8-1.
I am.
item 4,
Wait, please, Your Lordship.
Yes.
Lordship, this is the second bail application, Your Lordship. And today completed 133 days in custody, arrested on 31/7/2025, Your Lordship. And Lordship, the bail rejected order is page number 43.
The charge sheet has been submitted.
Charge sheet submitted, Lordship. I have annexer, Your Lordship. Charge sheet is annexer 4, page 27.
Charge sheet has been submitted under commercial quantity.
Yes, Lordship, and investigation already completed, and Your Lordship, the rejected order, page number 46 of the paragraph number 9, Your Lordship. Kindly may go to 9, Your Lordship. I have perused the WT message dated 31/7/2025. That is the date of arrest wherein the grounds of arrest are clearly discernible. The said WT message is addressed to the SHO Irilong, Imphal and SHO Thobal, Manipur from the SHO Dilai PS Karbi Anglong. In the said WT message, a request has been made to inform of the above mentioned accused persons regarding their arrest and grounds of arrest. Although there is no received acknowledgement on the said WT message available on the record or any returned WT message indicating servicing of the said notice, it appears that just 2 days later, 2/8/25, Bakalatnama was filed by the private counsel on behalf of the accused person, which prima facie indicates receipt of the WT message. Lordship, in this case, Your Lordship, I have annexed the WT message, Your Lordship. Kindly perused on page number 42 of the last 42, Your Lordship, page number last. The WT message was received by the brother of the accused person on 10/9/2025, and the accused are arrested on 31/7/2025, Your Lordship. I have annexed the WT message. And the typing copy is page number 41. In this WT message, there have nothing to be mentioned that grounds of arrest, and Your Lordship, nothing to be mentioned like that notice under section 48. Only the simple WT message. So, Lordship, that 48 notice is not compliant.
No,
Your
it is
Lordship.
stated here, and while transporting suspected to be morphine from Manipur to Assam. It is mentioned in the WT message.
Mentioned, but there have nothing to be mentioned that this is the grounds of arrest, Your Lordship. Paragraph is grounds of arrest. Where the notice of the under section 48, there has been mentioned that grounds of arrest is here. But it is a simple message, Your Lordship, and which was the receipt
No,
on.
what other ground is required? They were caught red-handed while transporting suspected morphine from Manipur to Assam using a Maruti Swift vehicle bearing number so and so. What other ground is required?
Lordship, written, but there have nothing to be mentioned that this is notice under section 48 at the up, and there have nothing to be mentioned that this is the grounds of arrest. And Your Lordship, this is the particular, which is the main of the WT message of the last. There have only received on 10/9/2025, Your Lordship. There have that is also mentioned. I have annexed page number 42. So he was they are arrested on 31/7. Okay, Lordship, they have sending that letter on 31/7/2025, but they could not receive, Your Lordship. We are going as per law, Your Lordship. And where is the Bihan Kumar judgment is also saying that the paragraph number 2.
You see, the difficulty now is that all the matters, issues you are raising now have been dealt with in the rejection order passed earlier. Now, how can I go and say that this
Lordship,
is not the case?
this is my point, Your Lordship. My point is here, Lordship. One is the criminal appeal, which I have annexed on the first bail petition also, Your Lordship. In this paragraph of the 17, Your Lordship, criminal appeal, I have annexed in this case also. Page number 80, annexure 9, Lordship. Again, I have annexed, Your Lordship. Paragraph number 17, Lordship. Kindly go to 17.
7-0.
17, Your Lordship. We have perused the record that have been bought by the appellant, though there is signature in the photocopy of the arrest memo of the accused respondent, which the appellant says is the signature of the brother of the accused. We find that there is no date affixed to the said signature. On the other hand, all the other signatures in the arrest memo, which have been signed by the witnesses, the arrestee and the officer making the arrest, all have that there is nothing to prove that the grounds of arrest had been received by the brother of the accused respondent on 25/2025.
Where are you reading? What are you reading?
Lordship, page number 88 in this
88.
petition.
You just now said 1717, then you jump to 88.
Yes, Lordship, paragraph number 17, page number 87 and 88.
Para 17.
Yes, Lordship, paragraph 17. So, Lordship, which is the arrest memo, Your Lordship, already scan copy status report and the case diary also received. Kindly go to arrest memo, Your Lordship. On this arrest memo, there we could not find the signature of the guardian, Your Lordship, of the brother or his relatives, Your Lordship. And so it is it could not indicate the signature of the guardian of the guardian signature in this arrest memo, Your Lordship. So which is the paragraph number 17 is saying on the page number 87 and 88, page number 87, 88, Lordship. Arrest memo of the accused respondent, which the appellant say is the signature of the brother of the accused, we find that there is no date affixed to the said signature. On the other hand, all the other signatures in the arrest memo which have been signed by the witnesses, the arrestee and the officer making the arrest all have dates. There is nothing to prove that the grounds of arrest had been received by the brother of the accused or respondent on 25/2025. Means, Your Lordship, the accused was arrested on 25/2025 of the bail application number 486/25. That the NIA has arrested the accused persons. They are also Manipur, and WT message was sent, but they have granted bail by the High Court. After then, NIA has filed this criminal appeal for cancellation that bail granted, Your Lordship, by the High Court. So, that the appeal of the NIA, this was dismissed by the division bench, Your Lordship. I have annexed this order.
These are the facts of that case.
Same facts, Your Lordship. This is the same facts of the bail number BA number 486/2025, which is granted bail by the Honorable High Court. After then, NIA has filed the criminal appeal for cancellation the bail allow order, Your Lordship. After then, that the division bench has rejected that.
In that case, the accused were different, their facts were different from the
That is
present
not the
case.
different, Your Lordship. In this case also WT message was sent and I have annexed the WT message, Your Lordship. In this WT message was received by the brother of the accused on 10/9/2025. This is clearly mentioned on the page number, Your Lordship. I have annexed. Lordship, kindly go to page number, WT message, page number 42. Maibang Santhoy, he is the brother of the accused person, received on WT message on 10/9/2025, and they are arrested on 31, Your Lordship, 31, and that is also received from the postal, Your Lordship, not from the PS, local PS. The local PS is.
But we have dealt with that aspect of the matter in the earlier rejection order.
Yes, Lordship.
How can we say otherwise now?
That is the grounds, Your Lordship. 48 is not comply, Your Lordship. It is correct, Your Lordship. So my submission is.
No, but we have held that there is compliance or there is no necessity of compliance given the situation in Manipur. That is what we have held. Now, how can we say otherwise now? You should have gone to the Supreme Court.
That is not said by Supreme Court judgment, Your Lordship. If they are from Manipur, if they are from Nagaland, if not received, then it is not come to 48. It is not saying by the Supreme Court judgment, Your Lordship. Bihan Kumar judgment also I have
Yes,
annexed here.
we have dealt with Vihan Kumar also in the earlier rejection order.
Bihan Kumar judgment also saying that.
How can we say otherwise now? You answer that simple question.
Lordship, kindly go to 74 page. Already read by this honorable.
Kindly go to Supreme Court.
No, Lordship. Lordship, it is not matter, but Lordship already searched also
See,
submitted.
we have held that there is sufficient compliance in our earlier rejection order. Can we now say that there was no compliance?
Lordship, earlier
Rightly
also-
or wrongly, we have said something. We can't go back on that now. Your only option is the Supreme Court now.
Lordship, not the 48 notice has been received by the accused guardian, Your Lordship. It is
There
correct,
is no
Your
point in repeating the facts.
Lordship, kindly, Lordship. Any condition
Yes,
can be
PP.
also submitted, Your Lordship.
Yes,
Investigation also completed, Your Lordship.
Yes, if prosecution concedes, we will allow.
Your Lordship, may I please, Your Lordship? My Lord, I
Yes.
would like to point out one thing, my Lord. Earlier, all these grounds were taken before Your Lordship. All these grounds were considered thereafter rejected. Now, same grounds were again reiterated before Your Lordship. I would like to point out, Your Lordship, page 88. Now, he is trying to point out the division bench judgment, my Lord. Your Lordship, again, I would like to point out page 88, my lord, that is division bench judgment, my lord. The third line, my lord. There is nothing to prove that the grounds of arrest had been received by the brother of the accused respondent on 2025. That is in the judgment of the division bench. And earlier, my lord, your Lordship rejection order, page 46. Your Lordship may come to my last portion, my lord. It appears that just 2 days later, on 2/8/25, Ukalatnama was filed by the private counsel on behalf of the accused persons, which prima facie indicates receipt of the W2 message. The accused persons were also represented by the learned LLDC on the date of production subsequently as well. So, my facts of this case is totally different. In that case, my
Not
lord, in
different,
fact,
Lordship. They are
my lord,
also W2
nothing
message.
was received by the, my lord, petitioner. There is nothing to prove that the grounds of arrest had been received by the brother of the accused. But here in this case, my lord, there is, my lord, clear observation of this honorable court that my lord order, my lord, notice was received by the WT message was received by the brother of the accused, thereafter appeared, and he also pointed out signature of the brother today before your lordship. So there is nothing in this case, my lord. All those grounds were earlier she has taken. My lord, your lordship has all considered, after considering those aspects rejected thereafter, my lord. So there is no new grounds at this point of time, considering the, my lord, huge quantity of morphine, my lord,
Lordship, this is
2.127
the
kg.
quantity of the page number 81.
My prayer
Page number
before-
81, paragraph
My
number.
lord, yeah, to me, call on my consent. So my prayer. So my prayer before your lordship, there is to reject this bail petition. There is no new ground, and all these grounds were earlier decided by your lordship. And the new ground, as pointed by my learned, my lord friend, I already pointed out to your lordship that the facts of that division bench judgment and my lord, the present judgment is totally, my lord, different, my lord. Here in this
Not
case,
different, Lordship.
the
Not,
notice issue
Lordship, paragraph
received
number 81,
hereafter, my lord.
Lordship. Page number
okay,
81,
here.
paragraph number 2. Page number 81, paragraph number 2, Lordship. In this paragraph mentioned that bail application number 486, 2025, in connection with the RC 5, 2024, NIA Guwahati, the respondent accused was arrested by the NIA in connection with the attack on IRB post located at IMA Kondong, Lairembi, More, Tengopal district by suspected Kuki militants, which results in the death of one security personnel. The accused respondent was arrested on 19 Feb 2025 at 3:30 am in the Silchar police station, Kasar, Assam. So may allow for submit that bail application order 486/2025.
Which page you are reading?
Yeah.
Which page you were reading just now?
Page number 81, paragraph number 2. In this appeal, your lordship, page number.
This was some militant resulting in death of security personnel. What? How is it similar to the present case?
Lordship, where is the 47, 48 grounds, your lordship, only for?
That
this
is what
case
we are
also-
saying. The facts are different in that case.
Yes, lordship, 47,
You are
48.
referring to the allegation in the page 80, annexion 9, division bench judgment. That dealt with a different case.
But in this case also here mentioned page number 7, the Sri Darshan.
Yes, all right. I think we have heard enough. We'll see what we can do.
Purukaistha and Bihan Kumar judgment also mentioned. Only for, we are going to the 47 and 48 BNS, your lordship. This grounds was not applied, your lordship. And WT message also sent in this case also, your lordship. But the brother of the accused respondent did not receive the notice, matlab WT message, your lordship, within the limitation period. This is mentioned in this order, your lordship, which I have read it. And your lordship, where is the Sri Darshan case, your lordship? There have been one of the citation of National Insurance Company Limited versus Pranoy Sethi of the paragraph, page number 86, paragraph number 15, here mentioned, wherein it was held that if there are conflicting decisions of the equal benches of the Supreme Court, then earlier decision should be followed by the High Court. Means Bihan Kumar judgment is the earlier judgment, then Supreme Court, which in this case matlab means Bihan Kumar judgment will be followed, Your Lordship, by the every High Court, Your Lordship. This is mentioned on
All
paragraph
right,
number
noted, yes.
paragraph number 15, Your Lordship. And the WT message which was sent by the NIA, this is also mentioned in this. WT message. Paragraph number 17. Yes, Lordship. Paragraph number 16. Paragraph number 16, page number 87. Keeping in view the decision of the Supreme Court in the case of State of Karnataka versus Darshan, we are of the view that the non-furnishing of the grounds of the arrest in writing to the family relatives of the arrested person immediately cannot be said to the legal or violative of Article 22 Clause 1 of the Constitution of India and Section 47 of the BNSF. However, the grounds of arrest have to be furnished within a reasonable time. In the present case, the accused respondent was arrested on 19/5/2025 and till the date of filing of the written objection by the appellant in bail application number 486/2025, 2/6/2025. The brother relatives of the accused respondent had not been provided a copy of the grounds of arrest. Means, Lordship, they are arrested on 19/5/2025. Till 2/6/2025, no any notice has been no provided a copy of the grounds of arrest to the relatives or accused or respondent, Your Lordship. Had not been provided a copy of the grounds of arrest. This delay of the approximately 18 days, in our views, is beyond reasonable time, keeping in view the decision of the Supreme Court Bihan Kumar. As such, the requirement of making the relatives of the accused respondent aware of the grounds of arrest of the accused not having been met within a reasonable time. And our WT message was received on that date 9/9/2025, arrested on 31/7, Your Lordship. This is my submission, Your Lordship. Our WT message also here I have annexed. Yes, 10/9/2025, received this message. In earlier, there have no any signature of the accused relatives, Your Lordship. That on 31/7 they have received, there have no any proof, Your Lordship. That the notice has been.
Yes, all right.
Guardian or relatives, Your Lordship. So, Lordship, there have a delay, Your Lordship.
Yes, next. We are
I-
reserving order.
Item 1.
Item 1 of Guwahati.
Any condition, Lordship, they may be allowed, Your Lordship.
Anybody for item 1? None appears, release the matter.
My lord, I seek your lordship's
Just
indulgence.
a moment, we are dealing with principal seat now.
Lordship, second bail application, Your Lordship. Earlier rejection order, Your Lordship will find it.
Oh, you are here.
Lordship. Page 36, Your Lordship. Nothing
Page?
has been. Page 36, Your Lordship.
This is NDPS.
DPS, Your Lordship. Initially, the case was registered under section, Your Lordship, 21B and 25, Your Lordship. Later on, Your Lordship, section 27A and 29, and Your Lordship 1112B of the BNS was, Your Lordship, added, Your Lordship. Already 120 days in custody, Your Lordship. Main accused has already been released on bail, Your Lordship. From
We
whom
call for the CD.
Yes, ma'am, updated CD.
Lordship may kindly have a look to Your Lordship, Annexure Z, Your Lordship, page 32, Your Lordship.
Yes.
When he was, Your Lordship may call for CD, But your lordship may, in that case, your lordship may directly your lordship jail authority to provide your proper medical.
Pardon?
Your lordship may kindly come to page 33, your lordship.
33.
Yes, your lordship. Special note, your lordship. May I read your lordship?
Yes.
Refer to Department of GI Surgery, AMCS, GMCS for further management and advised by the Department of Surgery, JMCS, your lordship. He is in jail, your lordship. Lordship may directly, your lordship, jail authority to admit him in JMC, your lordship, AMCS or your lordship, GMCS, your lordship, for further treatment, your lordship.
He is now in which jail?
Yes, Jorhat jail, your lordship.
Jorhat jail. Jorhat has medical college now.
Yes, your lordship, Jorhat Medical College. He was admitted in Jorhat Medical College, your hospital, from your lordship 26/9/2025 to 7/10/2025, your lordship. From there, he is recommended to your lordship.
No, what do you want now? To refer him to which hospital?
AMCS or your lordship, GMCS, your lordship. Assam Medical College Hospital, Dibrugarh, or Guwahati Medical College Hospital, your lordship.
No, what is the difficulty with Jorhat Medical College?
Jorhat Medical College is recommended, your lordship. That is your
MCH, GMCH. So they don't have the facility.
Yes, your lordship. He was admitted there from 26/9/2025 to 7/10/2025, your lordship.
All right, heard learned counsel for the petitioner and learned additional PP. Peruse the application under section so and so, praying for bail. Call for the updated CD. Para it is submitted by learned counsel for the petitioner that the petitioner is suffering from hiatus hernia, HIATUS, HCRNIA hernia, and pan gastritis, PAN gastritis. Okay, page 33. And the medical officer of Jorhat Medical College and Hospital has referred the petitioner to the Department of GI Surgery, AMCH stroke GMCH for further management as advised by the Department of Surgery, JMCH. Para considering the same, it is directed that the superintendent of Jorhat is district jail or central jail?
District jail, ma'am.
District jail, yes. District jail, Jorhat shall make necessary arrangements for sending the patient and the petitioner to AMCH stroke GMCH as may be convenient within a period of 2 weeks from today. Not within a period, say no later than 2 weeks from today. And submit report accordingly. Place the matter again on
8-1, my lord.
Lordship may kindly fix it on 19th, your lordship. 19th, your lordship. Last day, your lordship.
last day of
This year, 19th of December, your lordship.
19th of December. This bench will not be available.
In that case, your lordship, January. Oblige, your lordship.
What date?
Please, your lordship.
Date.
Lordship, one is my request, your
What
lordship.
date do you want? 8th.
Lordship.
Yes, my lord, 8, my lord.
Huh?
8-1.
8-1.
8-1.
All right. 8-1.
Apply, your lordship.
One is my request, your lordship.
Who are you?
Yes, lordship. Page number 75, I have annexed the bail application number 2813 of the 2025.
Sorry, we are over with that. Yes, call up next item.
1 minute.
Eyes on bench. Any mention?
Switch that off.
My lord, I seek your lordship's indulgence in mentioning item number 9, part 2. So I'm appearing on behalf of my senior Silal Fakzwala, who is the amicus curiae in this matter. And my lord, this is a prayer made by board councils, and this matter may be listed after vacation.
All right, on the prayer of learned counsel for both the parties, list the matter after the vacations.
Highly obliged.
My lords, I beg to mention part 2, item 3, my lord.
Courtmaster, switch off Guwahati.
Part 2, item 3, my lord.
Yes.
I've taken the consent, my lord. It may come up after the vacation, my lord.
All right, part 2, item 3, after the vacations.
Oblige.
Your Lordship's indulgence regarding item number 1 of part 2, my lord. As Mr. Priyanshu Goswami is having some personal difficulties, if the matter can be kindly fixed for 16th of January.
All right, prayer of, for respondent,
Respondent number 5.
prayer of learned counsel for respondent number 5, list the matter again on January.
And my lord, if I may allow to make a similar prayer regarding item number 4 and 5 of hearing list.
All right.
I'm obliged, my lord.
Daily list for motion, item 1.
May I please, Your Lordship?
Yes.
On the last court date, my lord, I was instructed to furnish FIR copies along with the charge sheet, my lord. And
Yes, what is the case about?
my lord, this is a criminal petition filed under section 528D to section 484 of the BNSS for reduction and modification of the bail bond in criminal miscellaneous application 449 of 2025, my lord. Wherein I was
What is
allowed
the
to,
condition?
my lord, in page number 43, my lord. Page number 43, the last paragraph, my lord. I was
It was already reduced from 20 to 10.
25 lakhs to, my lord,
25
10
to
lakhs.
10. So how much reduction can be given?
My lord, my humble prayer before this lordship is that I have in my petition,
We'll be left with no profit margin if we give so much of reduction.
in which, my lord,
There must be a reason why such a high amount was imposed. Who are you? Yes, who are you? What is your name?
Malsom, my lord. Malsom and Roland Sang, the petitioner. My lord, the role of involvement,
Malsoman Lonchio.
yes, my lord, 1 and 2, the petitioner.
What is your address otherwise?
My lord, my address are inside the state of Mizoram, but different locality, my lord, different district. Page number 5, my lord.
Yes. What is the actual allegation against you? Where is that?
My Lord, though I have not annexed in my petition that I have submitted the charge. My role of involvement is in page number. I was accused of conspiracy, my Lord.
Were you in the vehicle or not?
No, my Lord. I was in the scooty, which was also seized in the instant case, my Lord.
Scooty?
Yes, my Lord.
Where was it seized from? From near the vehicle.
Yes, my Lord.
So you're the escort party.
No, no, my Lord. But, my Lord, nothing was recovered from the vehicle, my Lord. The seized article were recovered from the
But now, what
jungle.
is your difficulty? With the amount or with the any other condition?
With the amount, my Lord. 10
Amount?
lakhs. Yes, my Lord.
Other conditions you are happy with?
Yes, my Lord.
Yes, prosecution.
Your Lordship, actually, my Lord, in terms of Section 21 of the NIA Act, Your Lordship, all appeals from Special Court to High Court will have to be taken up by bench of two, Your Lordship. Bench of two judges. Division bench, actually.
Is this a appeal against rejection of bail?
Actually, my Lord, any petition from the order of
See, let us see NIA Act.
Section 21, Your Lordship. Subsection 1, Your Lordship. It says, notwithstanding anything contained in the court, an appeal shall lie from any judgment, sentence, or order not being an interlocutory order of a special court to the High Court, both on facts and on law. Subsection 2, Your Lordship. Every appeal under subsection 1 shall be heard by a bench of two judges of the High Court. In the meantime, my Lord, if it's only now not...
So what were you doing? You could have made a prayer for listing it before the division bench yesterday.
Yes, my Lord.
Now you have to wait.
But, my Lord, however, in this Supreme Court judgments, which point number 6, which stated that if the bail bond are not furnished within 1 month from the date of grant of bail, the concerned court may sue motu take up the case, my Lord.
That will not concern us.
Point number 6, my Lord.
So which is the concerned court? It says if the bail bonds are not furnished within 1 month from the date of grant of bail, the concerned court may suo motu take up the case. Which is this concerned court now?
I hope this is my Lord.
All right. In view of section 21 of the NIA Act, this matter is required to be taken up by bench of 2 judges. Hence, place the matter before the next available division bench.
Obliged, Your Lordship.
Much obliged.
For admission, item 2.
My Lord, on the last court date, the respondent number 7 were directed to file affidavit, my Lord.
Who are the respondents now?
My Lord, the respondents was usually represented by Mr. H. Gupta, my Lord.
Huh?
Counsel is Mr. H. Gupta, my Lord. And
The service is complete on all the respondents.
yes, complete, but my Lord, we have to file impleadment again. We have found out that there are some new incumbents again, my Lord, during the last court date, my
So you
Lord.
need time to file impleadment, or have you filed already?
No, I have to take time, my Lord.
All right, as prayed for by learned counsel for the petitioner, seeking time to file fresh impleadment application. Please the matter again on, give a date.
19th of January.
Much obliged.
Item 3.
Lordship, we have received affidavit in opposition from the respondents, and we would like to file the reply against the affidavit in opposition of respondent number 4.
Learned counsel for the petitioner prays for 2 weeks' time to submit reply to the affidavit in opposition filed by the respondent number
4.
4. Hence, list the matter again.
22nd January.
Obliged.
Item 4.
May it please the Lordship, I am here for the petitioner. And my Lord, as per the last court order dated, the respondents were allowed to file their affidavits in respect of the additional affidavit and affidavit in reply to the affidavit in opposition by the respondent number 1 to 7. And regarding the respondent number 8 and 9, they have to file the affidavit in opposition, my Lord.
Lordship, I'm respondent number 8. I have not yet received affidavit filed by respondent number 1 to 6. So I may be given time for filing my counter sometime.
Respondent number?
8.
8.
As prayed for by learned counsel for respondent number time 8. Four weeks' time is granted to enable her to file the affidavit, counter affidavit. You furnish copies?
Yes, Your Lordship, I will furnish. And Your Lordship, newly impleaded respondent
Then
number 9.
Respondent
number 9 is newly impleaded, Your Lordship. And with regard to that, we will not file separate affidavit. The newly impleaded is also the state respondent.
Yes. So what order is to be passed in that regard?
Actually, in the last court date, they have to serve the course title, newly.
The amended course title, my Lord. We have served to all the parties, my Lord.
You have filed the impleadment application already?
Yes, my Lord, and already allowed, my Lord.
Already allowed?
Disposed, my Lord,
It is
yes.
further submitted that an impleadment application, impleading respondent number 9 has been allowed, and accordingly The course title is required to be corrected. Registry is directed to correct the course title.
My lord, even the course title already corrected, and the
Alright.
yes, my lord.
Then what is required now?
Actually, Your Lordship, in the last court date, I was given time to get instruction whether I will submit it a separate affidavit with
You can't
regard to
deadline, okay,
newly
deadline you
impleted. But what my submission is that I will not file a separate affidavit.
Okay. Learned counsel appearing for respondent number 9 submits that no separate affidavit will be filed on behalf of respondent number 9. Is the matter again on?
And my lord, one request, the interim order passed earlier shall continue, my lord.
Interim order passed earlier to continue. List the matter till the next date of listing. List the matter again on
19th of January.
19 January. Obliged, my lord.
Item 5.
My lord, this matter was earlier taken upon this last Monday, and
Your Lordship, I'm sorry, I'm just interrupting. The first one, item number 4. So there's one thing, similar matter. This may be clubbed together, same parties, similar matter.
just the previous case.
Yes, and WPC number 141 of 2025. Maybe
Yeah, you
clubbed
added
together
line,
and
list,
list
list the
together.
matter on so and so along with WPC number.
141, 2025. Lal Rosara. Much obliged.
And your lordship, this matter is pertaining to suspension of the Chakma Autonomous District Council, Village Council, my lord, Kamalanagar, Village Council, Kamalanagar 4, my lord, under CADC, Chakma Autonomous District Council.
So you are supposed to come up with the
Yes, there is the
definition of executive
yes
committee.
CCB rules, Constitution, Conduct of Business rules. My lord, the definition of executive committee, your lordship had inquired earlier. That is at page 2. And I'll come to the exhaustive definition thereafter. Page 2, subclause K. It says, my lord, executive committee of the district council of the Chakma Autonomous District as formed under these rules. So how it is formed is given at page 14, 1-4. Page 14.
Yes.
May I read, my lord? This
Yes.
I'll read only some part. There shall be an executive committee of the district council with a chief executive member at the head and 5 other members of the executive committee to exercise the functions hereinafter specified. The executive committee shall be formed by the largest legislature party having a majority of elected members in the district council. The leader elected by such legislature party shall be appointed as the chief executive member. Provided that in case he is not an elected member, then unless such leader is elected as a member of the district council within 6 months from the date of his appointment as such, he shall cease to be the chief executive member and to continue as such. Subject to Rule 2, Sub-Rule 2, the chief executive member shall be appointed by the governor and other members shall be appointed by the governor on the recommendation of the chief executive member through the secretary to the government. This is how executive committee has to be formed, my lord, by the largest party, legislature party.
So it is something akin to Council of Ministers.
Yes, it is similar to
Governor,
council.
Chief Minister and other ministers.
Correct, my lord.
Correct that way.
Correct.
So coming back to the case.
Coming back to the case, my lord. Now, the suspension order, my lord, if we look at the suspension order, impugn order is at page 83. The retyped copy is at 84, my lord. Page 83, third paragraph.
I'm referring to writ petition. It says that, my lord, in exercise of powers vested under section 14(1) of the Chakma Autonomous District Council, Village Councils Act 2003, Deputy Commissioner Longklai and the caretaker of Chakma Autonomous District Council is pleased to put Kamal and the Garfor Village Council under suspension for a period of 3 months. The first point I'm raising is that, my lord, it is the caretaker, deputy commissioner, who has no power, or he is not the executive committee. But the act says clearly that it should be executive committee. And my second point is that I'll come to the rules, the act itself, my lord, later. My other point is, the main point is that there is no provision for suspension of the village council. The only provision which is present is for dissolution. And if we look at section 14 of this village council act, my lord.
Yes, where is that?
It is at page 40. Page 40, my lord, at the bottom of the page, serial number 9, amendment of section 14. In section 14 of the Principal Act, the following clause shall be added, namely, the executive committee shall have the rights to interfere in the village administration in case of mismanagement of village council funds or maladministration in the village council. And how it should interfere is given under section 26 of the Village Council Act, page 36, my lord.
No, but before that, this is only the amendment part, but where is the full section 14 as it stands
Yes,
now?
it is at page 32, my lord. Page 32. Section 14, the power of the executive committee, man.
Which page was this amendment part?
Amendment is at page 40. Para 9.
Yes.
And my lord, I'll come to page 36. This is the only procedure, the only power how the executive committee could intervene, and take action against the village council, my lord. This is section 26. I may read, my lord.
Yes, I have already read.
Yes, yes. This is regarding dissolution only. And caretaker, how to appoint also, my lord. It is clearly given here.
So the entire power is with the executive committee, whether
Yes.
dissolutions, even if it is assumed that there is a power to suspend,
Yes, my lord.
con- included within the power to dissolve, so that is also to be exercised by the executive committee.
Correct, my lord.
So is there an executive committee in existence or not?
No, it is under suspension, my lord. The whole Autonomous District Council at the time of issuing of the suspension order. But anyway, the act itself clearly prescribed that it is the executive committee's power only. But assuming on
No, we are concerned with this village council,
Kamalanagar 4.
Nagar 4 village council has been
Yes.
suspended.
Yes. And
So that village council can be suspended by the executive committee.
suspension provision is
No,
not
so
there.
whatever,
Yes.
suspension, dissolution.
Yes.
Dissolution of a village council by the
Executive Committee of the Chakma Autonomous District Council.
Yes, so
Yes.
that is in existence, is it not?
Yes, it is in existence, but the executive committee was under suspension due to the governor's order at that particular time.
All right.
It was put under suspension. And caretaker was appointed, that is the Deputy Commissioner, Longklai District.
So he exercises the powers of the executive committee.
Yes.
What what provision that suspension takes place of the
Uh,
executive committee? Governor's powers is defined.
Now
there?
it is under 6th schedule, my lord, of the Constitution of India.
All right.
So even if
So
the-
now the only point remaining is whether the power to
suspend,
suspend is available.
that is what, my lord.
In view of the provisions
Yes.
providing only for
Yes.
dissolution.
Apart from the other allegations which we have mentioned, the allegations is that the village council president is ill for a long time, then he could not function properly. But that was the verification report said that it is not true. And the other allegations, all the allegations are like regarding payment for some works, for some NERGS works. There is some doubt is there. That is what the verification report says. And the other verification officer also, he said that it is not true. But my main point is that there is no provision at all for suspension. And now it will be expiring of 3 months suspension will be expiring on this coming 15th December. That is why I am pressing, my lord. Now I have served dusty service, I have taken, and CIDC represent is not appearing till today. And if it is not going to be disposed of, my lord, my humble prayer is that let the suspension order may not be extended, my lord, without leave of this honorable court. Because it will become infructuous on this coming 15. And if it is again extended, then I have to challenge again, my lord. And that too without presence of any provision in the act. That is very illegal, my lord. Until now, there is no step taken towards dissolution of the village council. And now the term has started since March of this year only, my lord. It is 5 years terms. Duration of the village council is 5 years. And I can rely upon the judgment of this honorable court in the other.
The duration is 5 years. So how
5
much
years.
have you left?
5 years now, 2030. It will be expiring on 2030 only.
So this is a very newly constituted
Yes, my
village
lord.
council.
After it was rightly formed initially, then this thing happened. So if writ petition is allowed, my lord, then they can still go for the correct procedure, dissolution, if there is any prima facie ground for pursuing that procedure, my lord.
State is a party.
State is included as, only the deputy commissioner, the caretaker is included as a party. So for state to be a party, my lord, it has to be represented by the secretary. And here only the caretaker is included as a party. So it's difficult to say anything on our part.
Okay, we'll see.
Yeah.
We'll fix it for order tomorrow.
Much obliged.
Item 6.
Yes.
Your Lordship, this is an application for bail. Lordship, the applicant is an accused in connection with the connected case in which charge sheet number 42 of 2025 has been submitted on 3/9/2025. Lordship, this is a case arising out of Zokotar PS case number 36 of 2025, which was registered on 14/3/2025 under section 21C/25/29 of NDNPS Act. Lordship, the accused applicant was arrested in connection with the said case on 15/3/2025. In connection with Zokotar PS case number so-and-so, on alleged seizure of 440 soap case of brown sugar suspected to be heroin, weighing 4.722 kgs from the joint possession of accused Suan Somlala, son of Pao Muan Thanga from Champai, and accused Vanal Shiata, son of Lalpeg Rule of Zokotar, on 14/3/2025 at around 6:30 a.m. The seized articles was said to have been recovered at a distance of about 30 feet from the new Huaycon Road, at about 3 kilometers from Huaycon village towards Sampai, at the instance of accused Suan Somlala and Vanal Shiata, driver and passenger respectively of one taxi having registration number MZ04B0344. Lordship, charge sheet was submitted already, and in this connection, the manner in which the applicant has been implicated in the case is on the basis of an allegation or the statement made by the co-accused. And Lordship, a perusal of the charge sheet submitted to the court at Champai would indicate that the case IO had arrested the 2 other persons, apart from the 6 persons stated here in the charge sheet. Your Lordship, I have an extract of the charge sheet which I have enclosed at page 13, starting from page 11, Your Lordship. Brief story of the case is at page 13. May I take Your Lordship to the brief story of the case? The prosecution story of the case in brief is that a written FIR is submitted by SI Zirthanga Pachuao, Zaukatar PS, stating that on the night of 13/3 at around 10:30 p.m., they conducted mobile vehicle patrolling at New Phuoikon Road, about 3 kilometers from New Phuoikon towards Champhai. 2 bikes having pillion rider and 1 Champhai taxi coming from New Phuoikon side towards Champhai were intercepted. At the time of asking about the riders of the bikes, the Champhai taxi suspected to be carrying illegal contraband items immediately ran away towards Champhai and chased the taxi. About 20 minutes later, the said taxi bearing number MZ04 B0344, driven by Chuan Somlala, son of Pauwan Thanga of Khuangpha village, Champhai district, and his passenger Vanal Khiata, son of Lalpek Ruala of Zaukothar, Taitesan section, were apprehended. 3 bikes, Yamaha R15 V4 silver color, unregistered, ridden by Zotan Sanga, son of Lalpek Liana, Zaukothar, Taitesan section, MZ01 01AA 8412 Jawa bike, ridden by Lalyan Moya, son of Lalmangai Thanga, Zaukothar, with his pillion rider, Ngansuan Pava, and MZ01Z4280 Yamaha R15, ridden by Nalmal Soma, son of Chung Loma of Zaukothar Neo section, with his pillion rider, Zomuan Sang 18, son of Rohlira Bethel Champhai, were also apprehended soon. On initial interrogation, they stated that they are transporting some contraband items in group, and the contraband items kept inside 1 nylon green sack and black garment bag dotted with multicolor were loaded in the said taxi but thrown away to the roadside after seeing police duty about 1.5 kilometers from police duty place by the said taxi driver Chuan Somlala and his passenger Vanal Khiata. Civilian witnesses of Zaukothar were called and ground of belief was also prepared. Search of the abandoned contraband items was done in the presence of civilian witnesses, namely Chansol Alkima and Vanal Ngur Sona. Both of Zaukothar and found 440 soap cases of suspected heroin kept inside 1 nylon green sack and black garment bag dotted with multicolor on the roadside, about 30 feet from the main road, on being led by them on the morning of 14/3/2025 at 6:30 a.m. Weighing was done in the presence of the said civilian witnesses, and all the 440 soap cases were 4.722 kgs and properly seized from the joint possession of the said taxi driver, Chuan Somlala, son of Pauwan Thang of Khuangpha village, and his passenger, Vanal Khiata, was also apprehended for further production. Said involved vehicle, taxi, bikes were also properly seized. Hence, ZKTR, that is Zaukothar PS case number 36 of 25, dated 17/1/25. Under section so and so was registered and duly investigated. During course of investigation, the seizing officer had prepared and submitted value of rupees 1,41,66,000 approximately in local market rate from the illegal possession of the accused persons in the presence of reliable witnesses, namely 2 civilian witnesses. After formally arresting the accused Chuan Somlala, Chuan Zothan Sanga, Nalyan Moya, and Nalmal Soma, Zoman Sanga. They were forwarded to MO, District Hospital Champai, for medical exam, police custody, or police or judicial custody. Juvenile in conflict with law, Ngansuan Pawa, was forwarded to Principal Magistrate JJB Champai to remand him. Subsequently, the accused, namely Chuan Fiata, Lalyan Moya, Nalmal Soma, Zomuan Sanga, were forwarded to CJM, District Court Champai, with a prayer for 72 hours police remand under proper escort. Accused persons admitted their contraband items for financial gain. Before this, they had transported contraband items several times from Zokota to Aizol. In this incident, Zotan Sanga was the leader who spoke to Ruan Tansungi of Komoy, Myanmar, and he summoned his friends to transport the contraband items from Zokota to Aizol for financial gain. From the statement, they will earn rupees 2 lakhs and will be subdivided among them. They were forwarded to CJM, Champai, for judicial remand on 17/3/2025. Thorough interrogations conducted during detention period at police custody, and it was revealed that unknown persons were waiting for them to receive the contraband items at Aizol as arranged by Run Tansungi Nusungi of Komoy, Myanmar. Therefore, SI Zirthanga Pachau and party rushed to Aizol and apprehended 2 persons, Henry Lalbiak Zinga and Laltluang Zela, who is the present applicant, who were waiting for the contraband items at Falkland. They were arrested at the PS and forwarded to MO, District Hospital Champai, for medical examination. And MO opined that they were fit to be kept in police or judicial custody. They were also forwarded to CJM District Court Champai with a prayer of 48 hours police remand. Your Lordship, let me pause here. This is how they have been implicated on the basis of the statement of those other accused person, that is the taxi driver and the passenger, who were said to be carrying the contraband items. And on the basis of their own statement, the contraband items, which they said they had thrown off the road at a particular point in between Zokotar and Champai, that they had located the said contraband items. And after taking necessary investigation and interrogation of those accused persons, they said that there are 2 other persons who are waiting for the contraband at Aizol. And one of them is the present applicant Laltluang Zela. Nothing has been recovered from them, and it is only on the basis of the implication of the statement implicating the applicant that they are waiting for the said contraband at Aizol. They were arrested only on that ground. And here it is further stated, during their detention period, they admitted their guilt that they tried like each. From the statements before the incident, they had delivered methamphetamine to truck driver Sairang Road Aizol for financial gain and earned rupees 1 lakh each. As more interrogation was required, 2 accused, Henry Lalbiak Zinga and Laltluang Zela, were forwarded to CJM Champai on 17/3/2025 for another 72 police remand. Henry Lalbiak Zinga and Laltluang Zela know each other from their childhood at the Dinter Aizol, all the back from the bank transaction. The amount of money were transferred in between.
No, I'm asking about the police statement, 161 statement of the PW3, statement of witnesses. What is his name?
Freddy.
Your Lordship, we kindly come to page 49A, that is the English translation, where the PW3 statement is there. 49A, Your Lordship. On 22nd 5/23 at Zambak near Tangatul, when the police person seized heroin number 4 from a truck, we were present at the time and hereby sign as a witness to the incident. That's all it has been written, Your Lordship.
Anti del box yellow with the list of anti
So these are PWs 2 and 3.
Yes, Your Lordship, 2 and 3.
2 and 3. Then 4. Who is 4? List is at page?
49A, Your Lordship.
Freddy, 2 and 3.
49A.
Then
49 is the in the
4
in
is
the language.
Lanrem Ruata. He's special messenger. Okay.
Yes, Your Lordship.
Then Lanrem Ruata, he delivered the seized article. Okay, he said nothing about
PW5.
Lanrem Ruata. Then 5 is 5. Where is the statement of 5? Have you annexed?
Your Lordship, it is there in the chart sheet, Your Lordship.
It's page 48, Your Lordship.
48?
48, yes. It's in vernacular.
What
The
does it
type
say?
copy has been annexed, Your Lordship, in 48A, Your Lordship.
Hmm?
This is the statement of this. She is the
Page
lady
48.
who helped
Where is
him
the
to get
translation of page 48?
I don't have the translation in my
48A,
copy.
Your Lordship. It is there in
48A.
the petition.
That is the wife of this one. Okay.
She is the one
She-
who
she
helped
was
him
not
to
at
get
the spot.
No, no, Your Lordship. She is the one
But
who
then
helped him
she
to get the
identified
Mizo
him to
registration.
be the.
Vehicle Mizo registration, she helped him.
Your Lordship,
She's not a
before
spot
we
witness,
further
Your Lordship.
continue, I do not have the translation copy of page 48A.
The page 48
sure
is in
you can
the
read the
Mizo
vernacular.
language.
I can read, but then it's not proper to have the file submitted before the court and not my file, the same one.
She is not a spot witness, Your Lordship. She was not a Caesar witness.
She did not depose to anything regarding the incident itself.
Exactly, Your Lordship.
The rest are FSL and this IO. So they will not have been at the spot either.
Exactly, Your Lordship. They are not. Your Lordship, as per section 37, I do get the benefit of doubt, Your Lordship.
All right, let's see.
Your Lordship, I just want to cite one judgment regarding the section 35, Your Lordship, as I
Note it
completely
down.
agree with my learned sister, but for the presumption of culpable mental state, Your Lordship, there has to be a preponderance of fact has to be there. 2023 INSC 424, Your Lordship, Harbhajan Singh versus State of Haryana.
All right.
In para 8 of that judgment, Your Lordship, very clearly it has been mentioned that we have considered the arguments of the
Please
advance.
note down the judgments. Okay. Say it again.
Yes, Your Lordship. 2023 INSC 424 Harbhajan Singh versus State of Haryana. I will also leave it in the chat.
Yes.
Item 8.
Oblige, Your Lordship.
Hello, still time. Lordship, if the matter can be continued.
Yes, have you gone through?
Your Lordship, it is there. First of all, in the first remand order, intimation of legal rights is there by the magistrate. And second is that in section 47, which I have flagged,
This first page, the blue flag mark, that is the first order.
yes, in the last paragraph is stated there. I informed them of the legal rights in the last paragraph. No, not in the same page, Your Lordship, in the same page, the flag page, the last paragraph. Right. Mm.
Where is this 47?
Your Lordship,
Pink.
the second flag, yes. Orange color flag, yes. Pink color flag. It is written clearly that intimation is given to the family relatives also. And it was countersigned by the accused himself.
So where are the grounds?
The grounds is in the,
Where? This is the document.
yes.
This seems to be discontinuous. This part seems to be different and the bottom part seems to be different from a
Yes.
different page.
Yes, it seems to. But that is whatever we can get from the record only.
This bottom part pertains to this page. Arrest court surrender form. I do hereby inform you that you are arrested under section so and so and also communicated to your relatives in language of your arrest.
Yes. And Your Lordship, in the subsequent pages, checklist is there, so that he will not escape bail, so and so is there. It is written under the heading checklist of arresting so and so.
Checklist, okay, these are reasons for arrest, not grounds of arrest, to prevent such person from committing further offenses for proper investigation, etc.
Though the section is not mentioned, that is the ground of arrest.
Which one? Ground of arrest is particular to the facts of that particular incident. That is the ground of arrest, that he was found in possession or whatever, and under these circumstances, he has been arrested. Others are just reasons for arrest.
But then they were intimated of their rights and they were produced before the learner.
Where is that?
The first remand order, Your Lordship. Otherwise, I could not find from the record, that is scan records.
Even in the remand order, it doesn't say, I have informed them the grounds of arrest. It says, I have informed them of their legal rights, whatever it means. All right.
Lordship, I place certain
Yes.
judgments.
Yes, yes.
Uh, Since the grounds of arrest have not been informed to the applicant, he has every right to be released for violation of the constitutional provision under Article 22, 1, and even 21 of the Constitution of India. And, Your Lordship, in the case of Vihan Kumar versus State of Haryana and another, which Your Lordship is well
That
aware
I
of.
think you have already supplied.
Yes, and the other one is Mihir Rajesh Shah,
Yes.
2025 SCC Online.
Yes. Yes, we have already gone through this recent judgment, so we'll see.
Right.
We'll pass orders later on. Yes, next case.
Item 8.
Yes, may please your lordship, I'm here for the appellant. And on the last court date, the TCR was called and has not yet arrived, my lord.
Where is the last order? Order is not here. Oh. So it's commercial quantity.
Yes, yes, my lord.
Okay, we'll wait for the LCR then.
Yes, my lord.
PCR has called for has not been received.
And my lord, if
Issue
this
reminder.
matter may come up as a fixed date.
Yes, list the matter again on, give a date.
15th of January.
Yes, my lord. Oblige.
Item 9.
Your Lordship, on behalf of the learned counsel for the appellant, she have informed me that matter can be listed for hearing.
Yes, paper book is ready and furnished to the parties. List the matter for hearing. After vacation. You can give a date also.
3rd of February. Item 10.
My lord, here notice is not complete, and in the last court's order, my lord, I was directed to ascertain the new address of the sole respondent, but I have done my, I've extensively inquired, and I've been informed that there is no new address. He had not shifted, and he is still staying in his present address, and I've been provided the landmark and his phone number as well. So, subject to your lordship's permission, if I may be allowed to take fresh steps with the precise address, my lord.
As prayed for by learned counsel for the petitioner, petitioner is to take fresh steps with precise address upon the sole respondent. This is the matter again on
23rd of January.
Oblige.
Your Lordship indulgence.
Yes.
In mentioning item number 1, Your Lordship of this day, even though Your Lordship, the order has already recently passed, however, if Your Lordship in your glorious magnanimity inclined to reconsider the order that has been passed, that in view of Section 21 of the NIA Act,
21
of the NIA Act, your Lordship has passed an order that the matter must be posted before the division bench. But however, in view of Section 21, Clause 2, Subsection 2 of the NIA Act, all the appeals and order from the order passed by the NIA Act must be appealed to the judge bench. But this instant criminal petition is Your Lordship filed under Section 484 of the BNSS, seeking your inherent power of this honorable court. So I think the matter must be for the single bench.
should have been submitted at the correct time. Just let me see the file.
In the meantime, Your Lordship, in Section 21, subsection 1, it states that notwithstanding anything contained in the court, an appeal shall lie from any judgment, sentence or order, not being an interlocutory order. And now this criminal petition is the same as interlocutory order, but filed under Section 528 of the BNSS, seeking inherent power of this honorable court. So I think the matter may be listed to the single judge. And if the same, since I already take consent from the other rival party, may be taken out tomorrow, since it involved the rights and liberty.
Whether question is not whether it's the application under 528 or 484, whatever. Question is, who is going to hear this? A single bench or division bench?
Single bench, Your
So
Lordship.
no, as per Section 21, any order,
But, Your
whatever be
Lordship,
the nature of the order,
Section
is
20
to be heard by division bench.
If I may insist, Your Lordship, Section 21, subsection 1 states not being an interlocutory order.
So how is this an interlocutory order?
Even though this is not the interlocutory order, but the bail order and rejection, civil criminal miscellaneous order that has been passed are the same as criminal interlocutory order. So the same may be
The bail order finally decides a valuable right of yours. How can it be an interlocutory order?
So even though this is not interlocutory order, but Your Lordship, since this is not an appeal against the order passed, but this is a criminal petition not against the order passed.
What is the language of that? Give me 21.
Section 21, if I may read, Your Lordship.
नहीं.
Subsection 1, Your Lordship. It states, my lord, that an appeal, but the instant criminal petition is not an appeal against any order passed by the special court.
Yes, suppose it is not an interlocutory order, first of all, is it?
Yes, it is not.
So it is an order. So notwithstanding anything contained in the court, an appeal shall lie from any judgment, sentence or order. So when an appeal lies, no revision lies.
Yeah, but Your Lordship, the
Then
instant criminal.
how can this be a revision? It
This
is
is
otherwise also not maintainable.
Your Lordship, but this is not a revision petition and not against that order, but it just, this is a criminal petition filed under Section 528 seeking your inherent power. So,
Criminal petition, you can name it in any manner, but when an appeal lies, how will this one be maintainable?
but if I may insist, Your Lordship, in my humble understanding, I think in view of Section 21 and in view of the instant criminal petition, since the same is not, the instant petition is not filed against the order passed by the special court, the same may not be considered as an appeal against the order.
And once we consider this as an appeal against the order, it will be before a division bench.
Yes, if Your Lordship so insists.
Because whether a criminal petition in exercise of powers under 528 will lie in this case or not, that will take a full scale hearing,
Yes, Your Lordship.
unless you can show some authority.
If the matter can be taken up tomorrow, Your Lordship, I will try to have some authority.
Hmm.
If the matter can be taken up tomorrow.
After?
Tomorrow, Your Lordship. Since it concerns the liberty of...
Tomorrow there will be no time at all. So it will anyway come after vacation.
Okay, Your Lordship.
So either in this form or in another form.
Yes, most definitely, Your Lordship.
So I think if it is listed before the division bench, then you don't have to argue on other things. Otherwise it's a very simple matter.
Yes.
Why take it through all the Mahabharata and everything, whether this lies, that lies? We are only on relaxation of bail conditions.
But Your Lordship, since...
I'm officer in view of Section 21, it should be before a division bench.
Yes.
And anyway, there is no scope for hearing the matter during these few days.
Yes.
So immediately on reopening, let it be placed before the division bench. Okay.
Yes, Your Lordship.